This is Amy Lord, and she grew up in Sioux Falls, South Dakota, and came out to Montana in high school. She went to the University of Montana and studied finance, also where she found the love of her life.
I'll introduce you later.
And subsequently went on to go to law school, also at the University of Montana, where she focused primarily on mediation and sort of collaborative kinds of law. Subsequently, she started her own law firm doing family law, and that's about what I have to say about that.
Here we are.
Here we are.
So usually when he does this introduction, we do a lot of co-teaching, and usually when he does that introduction, he tells you that I knew I wanted to be a lawyer from the time that I was in kindergarten.
He
forgot that part, and that's always like a really fun little story.
Yeah, sorry.
But it is what it is.
So Amy knew she wanted to be a lawyer. from a couple years ago.
Not a well-informed decision, but that's what I decided at the time.
She wanted to go to law school when she was in kindergarten because her mom worked for a lawyer, and sometimes when Amy was sick, she would go to work with her mom, and this lawyer also owned a Jelly Belly store.
Oh. And I know, the jig is up.
And would provide her with jelly. I mean, I'm sure they were basically medicine.
Right.
And what that lawyer, I think, said to her at the time was, you know, being a lawyer is great because you get to take care of other people, you get to take care of your family, and you can have all the Jelly Bellies you want.
Right.
So, in kindergarten, I think that had a fairly sizable impression on Amy, who knew from then on that was what she was destined to do. I think the work that she does now has proven that it was more than just a hunch to begin with. I think that it was what she was meant to do.
Yeah, I don't think that was actually a well-informed decision at the time. So this is David Lord. He grew up in Deer Lodge, Montana. He comes from a ranching family, although his dad is the second son in their family. So in addition to having a ranch, he also practiced medicine during his career. He retired a few years ago. His mom, who by education and training is a nurse, stayed home with the kids for a few years and then was a school nurse when David was in school. He is the youngest of a sibship of 3. And I think it's safe to say in the 15 years that I've known them, he is the mediator of the siblings, a good skill for someone to develop. Dave, unfortunately, in the time that we've known each other, he's lost most of his grandparents, and he had a first-hand look at what estate planning does for a family to maintain relationships and at what no estate planning does for a family, the impact that has on relationships. And so he decided to go to law school to be able to work with families and help them to navigate some of those difficult circumstances. I started our business 7 years ago. At the time, Dave was working for a law firm downtown, and unfortunately the economy did not allow them to hire him. So he did a bunch of networking, and the networking resulted in a bunch of clients and referrals, but not in a job itself. And so he decided to join me, and 7 years later, we are continuing to practice together. Our practice is all family focused, so we do some divorce work, some dissolution with kids, so parenting work, just parenting plans. We do lots of adoptions. We also represent children in kind of 2 capacities. One is as part of these cases, dependency and neglect cases, where the Department of Child and Family Services has come in and is assisting a family on addressing identified concerns. And then 2, sometimes in high conflict parenting cases, we come in and do guardian ad litem work which means that we do investigations and bring recommendations to the judge about what a parenting schedule might look like. We, as part of our practice, do quite a lot of settlement conference and mediation work. As Dave said, that was a focus for both of us in law school. I think he highlighted it for me in the introduction section. But the truth is, both of us focused on alternative dispute resolution in law school, and those have been skills that have proven to be really impactful in our practice. I spent my day today doing a settlement conference for a family. And actually, a lot of those skills are applied on a daily basis to a lot of the meetings we have in these types of cases, these dependency and neglect cases, where we have lots of emotion and lots of issues around a table with a lot of different parties. So we have kind of a variety in our practice. When Laura contacted me and asked us about speaking today, she didn't have any specific topics that she wanted us to cover. So we came prepared to talk about the legal process and some of the abbreviations that are out there. I think that if you become familiar with the foster care system and you work with children that are in it, you will quickly hear a lot of abbreviations, and that can be really confusing. And so we can talk a little bit about the process and some of the abbreviations that go along with it. But we also want to open up the door to any questions right off the bat. We have both represented about probably 100 children total, maybe more, over the course of the last few years. And I think it's safe to say for both of us that when we have the pleasure of working with foster families, one of the hardest things for us is not being able to give legal advice to them. Often foster parents ask us questions, wanting to know if we advocate for them, and our job is a little bit more complicated than that. We can give information to you, but we can't give you legal advice because we're not your attorneys. We specifically are always attorneys that are appointed on behalf of children. So I'm happy to talk about the process and have you interrupt us with questions, or if anybody has a burning question that you want to ask first, we're happy to have this be a conversation.
And I think honestly we would prefer for it to be a conversation, because I think it's going to be a lot more engaging than just hearing us talk about legal processes are something that really gets a lot of people excited. So I would rather be focused on topics of conversation that are meaningful to you guys and answering questions that you have.
Does anybody have a question or a topic you want to be sure we address?
And it's okay if you're feeling shy or nervous right now and you don't want to speak up either. Anytime is fine.
So as guardian ad litems, if you are assigned to a case, to a kiddo, and that kiddo commits a crime, probably steals stuff, do you represent them? Or do they then get passed on to like the youth court or?
So that's a great question. I would distinguish this by first saying, in the context of a dependency and neglect case, we are the attorney for the child. So guardians ad litem are appointed in parenting cases only in this jurisdiction. So the only time our title is guardian ad litem is if two parents are in dispute with one another about parenting and the judge asks for an investigation and recommendations, then we have the title guardian ad litem. In a circumstance like this, that role is filled by CASAs. So court-appointed special advocates have the responsibility of investigating, reporting, and making recommendations in dependency and neglect cases. So I just want to use that language difference so that we're clear about what we're talking about. So in a dependency and neglect case, when we are appointed to represent the children, we are not appointed for subsequent criminal cases unless that's our area of specialty. So there are some, and we agree, and we consent. There are some attorneys that choose to represent parents and children in both criminal and this type of civil case. And then there are a lot of us, and I am one of them. Criminal law is not my area of expertise, and so I have assisted a child with one case, but that generally is not something that I do as part of my practice. That doesn't mean that we don't follow what's happening if there is a criminal case. Often we'll try to stay well informed with another attorney that's working on that piece of the case. But these dependency and neglect cases, there are a lot of times that parents and children have a civil case that's open with the state for legal custody, and then they'll have pending criminal charges. And in some circumstances, it's the same attorney that helps with those matters, and in a number of them, it's not. So most of the time, I would say no. The child would not be appointed their attorney in both cases being the same person. And to be clear, I think the other thing that I would say is that when we're talking about title, so in a dependency and neglect case, an attorney should be appointed for a child that is 8 and above, and sometimes under 8, depending on how the procedure goes. Any child over 8 should automatically be appointed an attorney. That's the age that the Supreme Court has helped to identify. Sometimes younger kids are also appointed counsel. And our job is to identify and advocate for the wants and the wishes of the child. So our client is the child. We need to work to get to know the child and identify what he or she wants and advocate for that to the extent that we can.
There's also a Supreme Court case that says that the line is a little bit blurrier than that, because obviously we're working with kids, and all kids are different just as all adults are different, and kids have varying levels of, of development and ability to express what their wishes are and willingness to express what their wishes are. And so there are also sometimes, depending on the ages of the children, that we are extrapolating out what their wants would be based on what their needs are. And there are also circumstances, if I have a kid that, let's say a 12 or 13-year-old that's saying, this is what I want, and everything in my being is saying, this is not good for you, I'm going to represent to the court what this child wants, and I'm also going to acknowledge that it might not really be good for that person, because I think the difficulty is, unlike working with an adult who legally has the ability to make their own decisions, whether they're good decisions or bad decisions, I think sort of societally we also are trying to balance sort of a kid's development and needs with what they're expressing that they want. The distinction between what our role is and what a CASA's role is that a CASA, which again, as Amy just said, is a court-appointed special advocate, the CASA's role is to just represent what the child's best interests are, and the way that they ascertain that is by doing an investigation, talking to all of the people that are involved, getting to know the child, and what they use that information for is then to report back to the court. They're sort of the eyes and ears of the court. And so we don't do investigations. We interact with our client. We interact sometimes with care providers for our clients, depending on sort of what's going on in any individual circumstance. But the dividing line is CASA is best interest of the child. Our role is mostly wants and need, or mostly wants, sometimes a little gray area with what they need to.
And one of the difficulties is, especially right now, and I'm sure that everybody in this room is acutely aware of it, but there have been a number of articles around the state in different news organizations and especially newspapers that have talked about the mass increase in cases. And so there are a number of families that are getting a lot of intervention, and the state is working with more families than it usually does by a lot. And what that means is that it taxes resources at every level. And I think that that's especially true when it comes to our CASA volunteers. We have a really amazing group of well-trained, dedicated individuals, but it's a volunteer responsibility. And there just aren't enough volunteers who can sign on to each and every one of these cases and live through the case with the cases. Theoretically, most of these cases should be wrapping up in 2 years or around that phase, because federally, the court has some time frames put on it by federal law, but there are some exceptions to some of those time frames, and so some of these cases end up taking 3 to 4 years, and because of that, I think it's especially difficult to ask volunteers to commit for that period of time. So in a lot of our cases, we have great CASA volunteers that can stay with the case, and in some of them, we either never get a CASA appointed or we get somebody that isn't able to stay through the end of the case. And so, sometimes our responsibility, as Dave says, kind of changes a little bit depending on who all of the parties are in any given case. And just as we probably, if we went around this room and talked about our family dynamics, would have different family structures. That's for sure true of our history. We have very different family structures. The same is true of all of the families we work with. I think that's one of the gifts of this type of work, is getting to meet a lot of different families and seeing how we can help them. The law is very clear, and I'm sure that this is especially hard for foster parents if that's your role, but the law is very clear that we want to reunify children with their families when it's possible and when it can be done in a healthy and safe way. And that means that the gift of being a foster parent is an even bigger gift, because you're agreeing to take in a child and form a bond and relationship with them, knowing that you can't guarantee what the outcome will be. And I can tell you that with the kids that we've worked with, some of those kids are so lucky to have had the relationships with their foster families in the time of crisis. But I would tell you that I recognize that that's one of the hard parts of this process, the uncertainty that comes with it. And it's hard for us too, because a lot of times the kids we work with perpetually ask, what's gonna happen, and we can't make promises of what that looks like. Yes?
What if you have a child that is, 13 or older, and they come to you and they say, I don't want to go back to my parents' house?
So
how can you advocate for them?
So if we are the attorney for that child, we would be meeting with that child on a regular basis. Sometimes just by ourselves, like in our office, or we'll go and do something fun together. Sometimes in a therapist's office if they have some professionals that are connected. I often touch base with the school for the kiddos I represent and see kind of how they're doing in different environments. And then I always try to figure out from the kids themselves, what is it that they want? What are their wishes? And then try to advocate for that in the court process. That doesn't change the law's priority to try to reunify families. That's always the standard that the court legally has to attempt if it's in their best interest. But the wishes of the child are absolutely something that can be factored in.
Well, and one of the reasons that we try to get the bigger picture by talking to therapists and by talking to people at the school and by, just trying to get to know these kids as well as possible, in addition, obviously, to talking to them directly, is that it allows us to have open and frank conversations about the things that they're expressing that they want. Attorneys are also sometimes called counselors, not in the professional therapist context, but I do perceive that part of our role in representing these kids is helping them to understand what their options are and what the likely outcomes, because the judge is the person making a decision in most of these cases in the end, if people can't agree, what the potential outcomes are. And so, if I have a client that is as you described, and I have actually been in that circumstance before, I can go and, file legal documents asking the court to do what the child wants. But one of the things that we have to remember is we also have to have a plan for what the alternative is too. I mean, I can't just go to the court and say, the kid doesn't want to go back with their parents, so we're not going to, that's not an option, even if we don't have some other plan either. And so we're not working in a vacuum. We hopefully, it is my hope that the team that is involved, the people that are working with parents, the department, the people that are working with kids, all of those people are taking sort of the bigger picture of what all of the options are and are doing the best that we can to figure out how we can best meet the child's needs in the end. And like Amy is saying, there is a very strong, policy lean to reunifying kids with their parents if it can be done so that the kids are safe. Because study after study would indicate that kids are emotionally better off in the long run with their parents if it's possible for them to be safe.
And I will say that, you know, part of what we did is kind of go through the legal process and kind of make some notes, so we can kind of walk through that if you want us to, but one of the things that I would say is that these cases have a lot of possible outcomes. You know, sometimes children are reunified with parents and then they don't end up maintaining a relationship with a foster family. Sometimes they're reunified with parents and they end up seeing the foster family just as an extended family. They go there for weekends or holidays, they have ongoing relationships with each other. You know, and in some circumstances, and to me, I want to be clear, foster family doesn't necessarily to me mean kin or a non-relative foster family. I kind of lump all foster families together, recognizing that the law favors having kin placements if you can. And of course, kin is not identified as blood. So legally, you can be considered a kinship family provider even if you're not related by blood to the child. It's based on relationship. So you can be a longtime family friend, and legally you're going to be recognized as a kinship provider and receive priority over a non-relative foster family. But when I talk about that foster families, I kind of just refer to any family currently caring for the child that is a non-parent as a foster family. And so in some cases, you've got different types of reunifications. Then you sometimes have cases where there's a long-term guardianship with a foster family. The parent, for whatever reason, may not be able to provide care, but they want to maintain their parental rights and they want to maybe work on trying to reunify down the road. And so there's the door left open through guardianship. And then I've also had cases where termination happens, either by a parent relinquishing rights or by a parent losing rights in the process of a contested hearing. But I will tell you that just yesterday I spent my afternoon on the phone talking about parent contact for a child whose parents no longer have rights. And that child, therapeutically, it's been determined, and he absolutely wants it, he wants contact with his biological family. He needs that contact with his biological family. So even though he won't return to their care between now and when he's 18, and he knows that, he knows the decision's been made, he wants contact. And we're at a place where we can talk about doing that and figuring out how to make it safe and how to make it supported so that he can function in the family environment that he's in and have some ongoing contact with his biological parents. And so I think one of the wonderful things about these cases is that you never know what's going to happen because different families can work out different conclusions and resolutions. But one of the hard things, I think, especially for kids, is not knowing what's going to happen. Because when we first meet kids, we're not ever able to promise certainty. The best that we can do, especially for older kids, like 13 and above, is make sure that they're informed of what the process is, where we're at in the process, and then check in with them to see if their needs are being met, and make sure that as things change and evolve for them, that we're meeting them where they're at, that we're getting professional resources if we need them, and we're figuring out what their desires are for the future. But it's a complicated line of work because no two cases are identical. Do other people have questions? I mean, it's super helpful for us to kind of go off of your questions.
Totally.
Yep.
What's the difference between guardianship and adoption?
That's a great question.
That is a great question. So adoption is sort of a more permanent legal solution in that adoption requires for parents' parental rights to be terminated, meaning that they no longer have any legal say in what happens with their kids. The difference between an adoption and a guardianship is a guardianship does not require that legal bond be severed. So a guardianship can be ordered people agree to temporary guardianships. People agree to long-term guardianships. The truth is, people agree sometimes to relinquish their rights and have their children adopted too. But I think that the biggest difference is a guardianship is never a closed door to someone coming back and asking a court for their parental rights to be restored. I mean, their
Except-
rights are limited.
Except in circumstances where rights have been terminated and guardianship is the placement. So
Right.
that's where it becomes complicated. So guardianships are intended to be a tool that if we could not care for our children for a period of time, we could have legally appointed guardians to stand in our shoes. Most of the time, the idea is in a temporary guardianship that you'll resume your parental rights at some point in the future.
And
In-
there are lots of different reasons that people do that too. I mean, if you are going to be sick and unavailable and you need someone else to have authority to, take your kid to school and agree to healthcare stuff and do those kinds of things. There are reasons to have a guardianship in place that are not just involved in these cases.
But I've also had children that if a child is an Indian child, the Indian Child Welfare Act applies for children that are enrolled members of a federally recognized tribe. And this becomes complicated because we have the luxury of having a lot of wonderful tribal affiliations, and some of them unfortunately are not federally recognized tribes, and so that can become complicated too. That's kind of a nuance all its own. But if you work with an Indian child, sometimes the tribe, even if rights are terminated with parents, will say to CFS, you have legal custody now. The court finds that you have legal custody. We will not consent as a tribe to adoption. We'll consent to guardianship. And that has to do with cultural preservation. And so most of the time, guardianships leave the door open to the possibility of it being evaluated later. In a few rare circumstances, the Department of Child and Family Services may have long-term legal custody of a child because parental rights biologically were terminated, and the tribe itself will say, we aren't going to have our children adopted. We are only going to have them placed as part of a guardianship. And of course, what that means is that if for any reason the guardianship doesn't work out, the tribe would receive notice. And then the tribe could help to determine whether there was another approved placement that would help to preserve those cultural connections. So what Dave is saying is absolutely right. Most of the time, guardianship is left with the door open to maybe revisiting the situation either in the near term for a temporary guardianship or even a long-term guardianship. Sometimes you can set them aside if circumstances have changed. Adoption, that's not the case. The only way a child becomes eligible for adoption is if parents have passed and are deceased and no longer have their rights, or if they relinquish or have their rights terminated. That's what makes a child eligible for adoption. Yep.
You just brought up an interesting point. You said if the cases are only for Native American children that are enrolled,
Eligible
Enrollable.
for enrollment.
eligible.
Yep.
Okay.
And that's a blood quantum issue based on tribe by tribe standards.
A 3-year-old that is not enrolled,
Mhm.
and they're not looking at enrolling her,
Is she eligible?
I don't know.
So usually if there's a case that involves an Indian child, there's a federal requirement that you give notice to the potential tribe. And what you do is there's an actual letter sent as part of the court file that says, I'll use hypothetical. Greetings, Salish and Kootenai tribe. Could you, Confederated Salish and Kootenai tribe, could you please let us know if this particular child is eligible for enrollment? And then the tribe is always very good at returning a letter that says yes or no. And if yes, then the Indian Child Welfare Act applies, even if the child's not yet enrolled. And the tribe could choose to get involved, could choose to take jurisdiction of the case if they want to. But it depends a bit on the tribe, because some tribes have significantly more financial resources and infrastructure than others. The Confederated Salish and Kootenai tribes have a major infrastructure and they have a support system, but some of our other tribes like the Little Shell, I've got cases where we've got ICWA applying to it, even though it's not actually a federally recognized tribe at this time.
Or the Blackfeet?
The Blackfeet is recognized and ICWA doesn't.
They don't have a good infrastructure though.
Right.
That's right.
Right.
Communication can be challenging with
Yeah.
some of the tribes, and I think, again, it's taxing resources. There are a lot of Indian children within their communities and on their reservations and off reservation that may be involved in the system, and that's not, singling anyone out. That's true of all of us across the board. But I think some of the tribes are especially taxed with those requests. They just don't have enough infrastructure to support the inquiries they get.
Well, and one other thing that I wanted to say about ICWA, in case people are confused or don't know. ICWA, again, means Indian Child Welfare Act, and really there are a different set of rules that apply to those cases that increase the level of investigation and the level of sort of reunification efforts that the department has to provide. And the sort of historical basis for that is that for a very long time in our country's history, there was a trend of removing Indian children for not a lot of cause, just because there was a perception that non-native parents were better parents than native parents. And so one of the reasons that the Indian Child Welfare Act exists is to counteract that. So there are increased requirements for what the department has to do in terms of investigating prior to removal. There are increased requirements for what the department has to do for attempting to reunify as well. I mean, and it's way more complicated, and I mean, a semester-long legal class could be dedicated to the ins and outs of ICWA, and so
I
it's
know
not
that's
something.
how we've dealt with them for
Right.
the last 2 years.
It's
Yeah.
a big learning curve.
It is. It really
And I
throws
will
out
tell
trying to
you
understand it.
that it's very scary, even for Native parents that are enrolled members of their tribe, to try to figure out what does this mean. I mean, I've got a case where the tribe wanted to assume jurisdiction, and neither of the parents knew if they could veto that. Can we object? Yes, either one of you can object, and that's the end of the story. But they didn't know. They didn't know because it wasn't something that they were familiar with. And so, they were familiar with all of these other customs and traditions, but they weren't familiar with what opportunities the Indian Child Welfare Act affords them. And so it's a learning curve for everybody, and it's very nuanced. I think it's safe to say that our judges are very sensitive to wanting to be sure to uphold those higher standards. And so judges in Indian Child Welfare Act cases try to pay really close attention. If you're ever in court during one of the hearings, especially in the beginning where they're doing the certificate of judge part, there's always an inquiry about the first language of each parent. Sometimes the questions sound just really ridiculous to English-speaking parents, but the whole idea, as Dave said, is to be protective. And so judges are forced to ask on the record, do you understand English? If not, what kind of translator do we need to provide for you? So that you're in the best position possible to know what's at stake here. And the truth is, those same services are offered for other non-native English-speaking families. It's just a matter of advocating for it. I represented a child who was born outside of the United States, but born on a military base. And that military base birth meant that the United States government became involved, and ultimately the state of Montana. But what we really had were parents that were U.S. citizens, but they did not speak English as their first language. And so I advocated to have the judge get an interpreter service so that we could have all of our hearings include an interpreter, because this is complicated enough language that you absolutely need somebody who can help to translate in your native tongue some of these nuanced terms. And that can be tricky. There are a number of legal services out there, but legal terms themselves can kind of be tricky. And so add another language and there can be confusion. And so I've advocated that for cases to make sure that we have people really informed, because ultimately that protects my client, the child. If their parents know what's going on and they're informed and they understand what the expectations are, it also protects my client to be sure that he or she is going to have the best opportunity possible to have this case help in whatever way it can.
So I have another question then. If you have a group of kiddos and their attorney never contacts the kiddos, never comes and visits, I have a 3-year-old, her attorney calls me every month, or he comes and visits, period. He has for the last year. He is always informed, he's always calling me, he's always checking in with her. I had a group of 5 We never, ever, ever saw their attorney, ever, ever. And as foster parents, we invest a lot, so when they go, if there's reunification, and we are an equitable placement home, if it doesn't, you know, if you see the kids are gonna go back and you know it's not a safe environment, and their attorney has never come and talked to the kids, never been involved, can you get a different attorney? Can you call somebody to report that?
So,
It's kind of frustrating.
sure, I'm certain that Amy has her own opinion about this, and she's certainly free to answer too. I'm gonna give a probably not super satisfactory answer to that question. I'm happy to engage in a conversation about it, but it's sometimes complicated too. I mean, the circumstance that you're describing, obviously I don't know anything about it, and I'm not responding to that. One of the circumstances that I've been in is to see that the interactions that I have had with kids are not I mean, depending on their age, their development, what's going on for them, to see that it can be a very upsetting event to have to interact with me about these very difficult circumstances involving their parents. It's not that I don't want to make sure that the kid is informed, but you know, if we're talking about a 4-year-old, 5-year-old, 6-year-old, you know, the circumstances sort of impact the approach that I'm going to take. I mean, obviously, if it's a child that is old enough to understand what's going on and to make decisions about all of those things, it's my responsibility to be interacting enough to understand, to be able to do my job.
But what I would say to that, so I want to back up a second. If you have an attorney that never contacts you or the child, absolutely, you can talk to the Office of the Public Defender or to the caseworker at CFS and ask how to get contact information for that attorney. Never contacting the child, to me, is a good reason to ask for someone else to be appointed. I think what David is saying is that whether you decide as an attorney to see a child more than once a month or every 2 months, sometimes depends on how the kids react to seeing you.
Yeah.
And that's true for me too. I mean, I've worked with kids that they know what my job is because we've talked about it, and sometimes that means that seeing them in their therapist's office is the most supportive environment so that they can process how hard it is to talk about what they want and what they're thinking. And so, you know, I'll also say to kids, I'm gonna see you next time and we're just gonna have fun. And we'll go do something fun together, we'll get to know each other a little bit, and I don't ask any questions about what they want. If they wanna say something to me, I'm all ears, but I don't ask. But fundamentally, I think what Dave is saying, and this is true, our job is to try to ascertain what their wants and wishes are. And for some kids, they feel very, very emotionally torn.
But you still have to be able to go and see them, because
That's right.
there's 6 months we had these kids, and
7 months.
7 months, I never seen or heard from an attorney.
And what I would say is
What
if
about
you never
CASA?
have contact, yes, there's absolutely a remedy
The
for
CASA
that.
worker was at my house absolutely every single week.
That's what I mean. I
Period.
wonder if CASA's reporting to your attorney,
Right.
because our CASA works with the whole team to
Right.
make sure.
So-
And the attorney's at the meetings, like when you go from, but CASA's the one who's been engaging the attorney for the children,
And if the
hasn't been
CASA is
involved
there,
at
I
all.
think that's a great suggestion, to even ask the CASA and say, hey, have you had contact with the attorney? We haven't. And to see if that can be a bridge to figuring out if there's a reason or what's going on. I would say no contact would be more alarming to me than if the contact is limited by circumstance because somebody else has a different relationship.
Well, and the other thing that I would say about that too is, I mean, it also depends on what this person is doing sort of behind the scenes too. I mean, are they having contact with the department about what's going on? Are they having contact with the CASA? Are they having contact with other people that are involved in the children's lives? Therapists, school providers, those kinds of things. You know, I mean, I just think it's hard to respond to specific circumstance questions with general information.
But my major question was, can you report it?
Sure.
Yeah.
So I think that the best places to reach out would be to the caseworker that's involved in the case initially, at least, with that concern. And if that doesn't seem like it's getting you anywhere, to contact the OPD, the Public Defender's Office.
So the Office of the Public Defender is responsible for providing attorney services to all parents in these cases. If a parent doesn't qualify because of financial earnings that exceed the amount that financially can get a public defender appointed. One is initially appointed, and then after a period of time, if that parent doesn't qualify, that person is removed from the case and they have to find another attorney of their own. And then children are also appointed attorneys through the Office of the Public Defender. Because the Office of the Public Defender has too many parties to cases to be able to do it all in-house, there are a huge network of us that just do this type of work as outside attorneys. And so this is a portion of the work that we do, and we have a contract with the state of Montana to do this work at a set rate, specific terms, for these types of cases. But if you're ever curious, how come this goes through the public defender's office, it's the infrastructure that supports it. So what Dave is saying is right. You could talk to your caseworker, let them know you have a concern, and then you could call the Office of the Public Defender and figure out if they could help you to identify who the person is. And what I would always say is, if you're frustrated or upset with an attorney, we're supposed to be trained and paid to have difficult conversations. So I'm always receptive to people having those conversations with me too. But I recognize that it's hard to have a conversation with somebody you haven't met yet. But don't ever hesitate to at least say, this kiddo wants to meet you or wants to see you. And I always say that to the kids that I work with. I always say, I'm your attorney, so you call if you need me and we'll make it happen. And that's why I see them in so many different places and environments, because sometimes it's really helpful for me to see, what is school like versus Watson's or, some other environment. Other questions?
Did we fully answer the question?
Yeah, you did.
We're both CASAs, and thanks for the plug, by the way.
You bet.
But we only have, one, maybe two cases at a time, so we see a little of this, but
Right.
I'd be interested in your observations about the differences in the 4 district court judges and how they, without even naming names, just to let people know what kind of variation they can expect, because I don't even know for sure. I work with 2 judges, and especially with foster parents that have kids, many kids maybe over a period of years, they might be in all 4 different
Totally.
courts, and it might be frustrating if they didn't.
Yeah, so I actually, on Tuesday, was waiting for a hearing, and another attorney was sitting next to me, and he hasn't lived in Missoula very long. He used to practice in Gallatin County in Bozeman. And I said, so what do you do? What do you do outside of these cases? And he told me that one of the great things about practicing family law in Bozeman was that all of the district court judges gave all of their family law cases to one standing master.
Oh, my.
So although it was frustrating, they consistently practiced in front of one judge. And if you had one case on one topic, you could use that as a good precedent for arguing for the next case with similar facts. And I thought to myself, wow, that sounds fantastic. That would be so much easier. What you are saying is totally true. So we have 4 district court judges in Missoula alone. And each of those judges, I think, has a different reputation for navigating cases a little bit differently. And we also have 2 full-time standing masters and 1 part-time standing master that help to facilitate some intervention conferences, so some court-ordered mediation processes, and/or some cases are being referred to standing masters. So you have like 6 or 7 people that could be helping to make decisions for these cases. And I do think it's true that people have kind of different stylistic approaches. I would say that these are some of the hardest cases that our court sees, and I think it's really emotionally wearing on judges, because I think they feel so responsible for these children and worry so much about what's happening. I think that some judges set really reoccurring hearings to kind of stay on top of cases, and other judges set the statutory hearings that need to be set but trust that work will be done outside of the court process. I think that, I think in terms of judges and kind of stereotypical stuff, I've heard a lot of rumors of what attorneys perceive cases to be, but I will say that I've had experience in front of all 4 judges, and I've never had a stereotype that I've been able to identify as being true. And maybe part of that is that these are cases that have a lot of federal guidelines in terms of timeframes, and theoretically there are supposed to be only a few exclusions and exceptions to those timeframes. And that doesn't mean that there aren't exceptions to the rule, but I think that What I would say is that based on the last 7 years of practice that I've done here, I feel like these are really hard cases for judges. I feel like they're not popular hearings. They're really taxing and wearing. I think it's really painful for them to terminate parents' rights. I think there are a few cases where maybe they've seen it coming long enough that it's an easier decision, but I think there are a lot of cases that it takes a lot of consideration and a lot of thought. And a lot of hearings, long hearings to kind of get enough evidence to feel good about it. I also think that these are cases that are almost always appealed because the public defender system has an appellate department that can appeal. And we're talking about constitutional rights. Your constitutional right to parent is one that is given to any biological or adoptive parent. And so those are major rights that are at stake. And so that's why there are often so many appeals, because there are ways that you can argue for opportunities, have enough efforts been extended. And so...
Well, and because the public defender is appointed for parents, they're not paying for a lot of those appeals. I mean, so where in just civil divorces and parenting cases and the other stuff that we do, it would be very expensive to appeal a decision that was made by a judge. It's not always the case in these circumstances. Sometimes it is, obviously, that you have to meet certain financial requirements to qualify for a public defender. But so one thing that I would like to say in response to that question harkens back to something that Amy said very early on, and I think is a point that I think it is really important to drive home. One of the most difficult things about these cases is the level of uncertainty involved. And if you talk to any lawyer, you're going to hear across the board in any kind of law, one of the most difficult aspects of our job is not having a crystal ball that can tell us what a judge is or isn't going to do. So when we are advising our clients in these cases, when we're advising our clients in our other kinds of cases, we can give a range of outcomes that are possible. We can talk about what our plans for how we're going to present information is going to be. We can be as prepared to do the best job as we can to do that, and we still have no guarantee as to what the court is going to do in making decisions. Because particularly in the kind of stuff that we do, where the judge is given massive amounts of discretion in just making a fair decision, they have just wide latitude to do whatever they think is right, and there's no way that we can guarantee what that's going to be. And so it puts a layer of uncertainty in all of these kinds of cases in particular, where, if a foster family is concurrent and wants to be a potential adoptive placement, and the court, sometimes these cases go on for years, and I've seen it burn foster families out to the extent that, they just couldn't do it anymore, not because they didn't love the kids and not because of all of that, but just because they couldn't deal with not knowing what was going to happen, and they couldn't deal with, the feeling that parents were given too many opportunities. And I'm not going to say that there aren't times that I've seen what a judge decided to do and disagreed with them, but ultimately they're the ones that get to make that decision, and all we can do is deal with whatever those decisions are. And I think that, like Amy said, the biggest part of the gift, and one of the reasons that I think I would really struggle, I give all the credit in the world to foster parents. One of the things that I would struggle with is that uncertainty, not like developing this bond and not knowing where that was going to go. And I think that the sacrifice that is the biggest part of that gift is acknowledging that in a lot of those circumstances, kids are going to be returned to their parents. A lot of those circumstances. And that's, it's impossible. It's impossible from an emotional perspective. I think there was a question over here.
Yeah, when you were saying that the judge has to make a decision, the judge makes a decision by heart, or do they go by evidence?
Oh, that's a great question.
I wish I knew.
Yeah, that's a great question. Obviously, there are laws that the judge has to follow. There are procedures for how the process has to go based on laws that the judge has to follow. And there's more than 100 years worth of case law that the judge has to follow, because there's a legal term called stare decisis, which basically means that if a decision has been made on these facts in this case, unless it's been overturned or changed somehow, a judge over here, based on those same facts, has to make that same decision. And so the difficulty is, like I was saying just a second ago, the decisions in these cases are given a lot of discretion, and the judge is the one that's in a position to weigh the evidence and to hear what all of the arguments are and to do the best job that they can. And so, I mean, the answer to the question, is it heart or is it evidence? Yes.
So on that note, if the parents can appeal, can the children appeal?
So,
If there's a legal basis, yes.
I mean, the parents have to have a legal basis to appeal to begin with. They have to be able to point to something that was done incorrectly in the process, or that, I mean, people don't appeal just because they disagree with what was done. People,
My case is happening.
what I'm saying is, people don't appeal because they disagree. People appeal because there is a legal basis to claim that something was done incorrectly. Sometimes the legal basis is to say the judge was so wrong that on either the facts or the decision that they made, that there's no possible way that any reasonable judge could have made that decision. But that's where it falls into this really broad spectrum of discretion that the law allows for judges to make. And so the answer is, can a child appeal? A child can appeal if their rights were not taken into account and there's a legal basis upon which to appeal.
And what I would say is that, back to the question about heart versus evidence, I mean, I think our judges all take very seriously the evidence that they receive. That's what they do every day, all day. They're also required to do age-appropriate consultations, and I hope that that is meaningful for our judges. I've certainly been present for a lot of those when it's been clear that kids have had a really strong impact on judges. You know, I will say, like Dave has talked about before, you know, when you're talking about younger kids, those are probably less meaningful visits. And that's not to be dismissive of how great little kids are. I certainly love them, but it's just an acknowledgement that it's much harder to have a meaningful conversation with a 5-year-old about where they want to be than it is with a 15-year-old. But either way, the judge usually sees that child firsthand or gets information from someone else, because that's what's determined to be best for that child. But a lot of times those age-appropriate consultations are really powerful, because they give the judge an opportunity to meet the child, hear what the child has to say about where he or she wants to be, and kind of get a gauge on how reasonable is this request. You know, how are you conducting yourself in other settings? And I will tell you that I've been present for age-appropriate consultations where judges have said, you know, you're getting ready to apply to college, you know, let me write you a letter of recommendation. And I certainly have to imagine that that can be a powerful vote of confidence, even if it doesn't change the college application itself. I think just having somebody in that position be supportive of you is a real gift for kids who have often experienced a lot of trauma and a lot of transition. And so, you know, I think probably it is a combination of heart and evidence to some degree, but evidence is always going to be something they have to look at and cite.
The other thing I would say, and this isn't in response to any specific circumstance, but based on my experience, the judge is often in an impossible position. I mean, there is not a good choice to be made in some of these cases. There's sort of the least harmful choice to be made, but there isn't. I mean, for the most part, I mean, people aren't cheering at the end of cases unless, you know, parents have done everything that they need to do and everybody feels great about reunifying kids. There really are not super happy outcomes. And I think it's one of the reasons that I would not want to be a judge. I mean, I would far rather be able to present the information as it is and have somebody else be in a position to have to make that decision, because, I mean, I've seen it happen, that it just, I mean, it clearly tears them apart to be doing anything, but it's still their job, so they have to. One of the other things that I want to convey, and this actually, at least in my mind, relates to what I was just talking about. One of the really happy things that I've learned in the course of doing this work, and we've been doing it for 7 years, is that correct? In 7 years of just representing kids, I have come across very few parents that didn't love their kids and want them back. I mean, I'm not saying that there aren't any, and certainly the ones that are in that position stick out in the person's minds. But there are very few people that fall into that category. So unfortunately, the people that are involved in these cases mostly have reasons that they are just simply either temporarily or permanently not in a position to meet their kids' needs. And it has nothing to do with desire. At the other end of that same spectrum, I haven't come across a single kid that didn't love their parent. Not a single one. And so,
To this day, I still do. But the problem is I was never wanted back by my parents.
I know
I was
that
a
story.
foster, I was a foster child.
I was too.
I understand.
Yeah. It's complicated.
Not from personal experience, but I understand deeply what you're saying. And I think it is an important message for anyone that is involved in these cases in any sort of way to understand that sometimes when we are trying to figure out what's best for kids and there is so much uncertainty about why we are trying to put parents in a position to succeed, it isn't about the parents. It's because, and I'm not the judge, and I don't know, I can't read anybody's mind, I don't have that crystal ball, but I have to imagine that when they're saying, yes, I will give this person one more chance to go to rehab or to go do whatever they think might help, it's not because I want to give this parent another chance, it's because I want to give this kid another chance to have their parent. And, you know, I think that that's so important to understand. There are so many reasons, whether it's lack of experience, like lack of life experience, whether it's lack of sort of parenting support, whether it's lack of parenting information, whether it's drug addiction, or whether it's mental health issues, or whatever it is. There are all sorts of parents that desperately want to be there and meet their kids' needs and are not in a position to do that. And from my perspective, the goal, the purpose of this process is to see if there's anything that it is possible to do to remove those impediments so that kids' needs can be met with their parents. And there are lots of circumstances, unfortunately, obviously, we all know this in this room, that it isn't possible.
Or it isn't healthy.
Or it can't be healthy for the child. And, you know, it's one of the things that makes this process so heartbreaking and so rewarding at the same time. To feel like I have been able to be there for a kid, to have these conversations about this really difficult stuff, to walk them through it, regardless of what the outcome is, can have a really, I think, powerful impact on the kids. And another thing that I wanted to say, when Amy was talking about the age-appropriate consultations, part of the reason to have the age-appropriate consultation is so that the judge can get an impression of how the kid is, what the kid wants, all of these things. But it's, from my perspective, at least equally important to make a child feel like they are part of the process.
Absolutely.
And to make them feel like their voice is being heard, and to make them feel like, in spite of the fact that the adults in their lives are appropriately the ones making decisions about what happens, that what they want and what they need matters. And so, to me, the purpose for those age-appropriate consultations, obviously depending on what the age is, really is, that's as much a purpose as anything else, like providing the judge to make information to make a decision.
Did you have a question?
Yeah, one last question to end the session. If you are given guardianship and a couple years down the road, the parents decide to take you to court and change things up, is the state going to still help you with that?
If it's
or-
done as part of this process, yes.
If the guardianship is done as part of the dependency and neglect case, then they are required to receive notice if the parents come back and try to modify that guardianship.
And they have to investigate again.
And at that point, they would have to investigate, and depending on what the circumstances are, may reopen the dependency and neglect case. So everybody would get, the people that were involved would get attorneys appointed again and that sort of thing. That's the other thing I want to say that I appreciate is difficult about this process. I recognize that as foster parents, it probably feels like you're developing these bonds and that you develop interests in these cases that are then not being represented in court. And I'm sorry that feels difficult.
Well, and that's why.
I'm sincere in that.
Well, that's why you can get notice of the hearings, and that's why you can be there. And if you decide to hire an attorney, you can. I realize the difficult thing is not having one appointed for you. But that does. But that doesn't mean you can't go to a hearing and express your own wishes. And if you're not getting notice, contact the county attorney, the deputy county attorney assigned to your case, and ask that they give you notice. That is totally allowed.
Thank you.
Thank you so
You bet.
much, you guys. I really appreciate that.
I know we haven't said this yet, but thank you so much for your willingness to be involved in this. There are nowhere near enough good foster families. And I'm not like drawing a distinction between good and bad foster families. I recognize that 99.9% of foster families are wonderful and there are not enough of them, so thank everyone that is involved in the process. These kids need more than they're ever going to get, and you are at least providing something. Thank you.
Thanks everyone for coming.
Yeah.